Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about defamation. Cases that should have gone to the Supreme Court of Canada, but didn't. Kate Barclay posted a comment on a Facebook page dealing with a relationship between a soil company and a city councillor. Her comment was essentially to the effect that the city councillor was in the back pocket of the soil company, and the soil company sued Ms. Barclay, alleging that her comment was defamatory. Now, most people hearing a statement like that there's been some sort of corruption or corrupt deal made between a councillor and a soil company, would think, in the absence of evidence to support that that's true, that statement is defamatory. But the court actually dismissed the soil company's action against Ms. Barclay, classifying it as a strategic piece of litigation against public protest and using anti-SLAPP lawsuit legislation. But this case raises an important question, given that this type of legislation is relatively new in legal history. How are these statements supposed to be assessed? If it's the type of statement in a social media context that would ordinarily be defamation, can it just be dismissed ordinarily without further evidence to prove that the lawsuit is brought for an improper purpose? As a business owner, don't you have an interest in not being subject to allegations that your company is involved in nefarious, underhanded, corrupt deals with politicians? Is that not the whole role of defamation law, to protect people from those allegations, to protect companies from those allegations, and to protect politicians from those allegations? Would this case have been different if the city councillor had been the one that sued Ms. Barclay as opposed to the soil company? All of these are important questions in how the interpretation of anti-SLAPP legislation should go, and to guide the courts in applying this legislation to summarily dismiss proceedings that might otherwise have merit. That's not to say that the comment that Ms. Barclay posted was automatically defamation, but was there any evidence in this case to support that there was an improper purpose? And who bears that burden in proving that? None of this is very clear in the law, and this needs more guidance from the Supreme Court of Canada. There was a great opportunity here for the Supreme Court of Canada to establish a clear test when it comes to anti-SLAPP lawsuits that would deal with circumstances like these to guide lower courts and to help individuals who are concerned about potentially being sued for defamation or concerned about the court costs associated with filing a defamation suit that's dismissed on the anti-SLAPP legislation grounds in making their decisions before a matter proceeds to court. Unfortunately, the Supreme Court of Canada didn't see the importance of deciding these issues and left this for another day, which means that there's going to be more strategic litigation brought against public protest, as well as more people who are successful in dismissing lawsuits summarily when there may actually be a valid basis for their claim. And it'll take another day for the Supreme Court of Canada to decide that issue. Cases that should have gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting these videos together. Like, subscribe, and share with your friends.